Thanks, Clementa. And it's my honor here to introduce John Clark, who is currently a senior counsel at the Miller Canfield Center in Windsor. He received his BA at the University of Toronto in 1976 and his LLB at the University of Windsor in 1980. He's currently a member of the board of directors at Hotel Dieu Grace Healthcare, and he's either presently or formerly a member of its various committees, including executive, governance, workplace excellence, and quality committees. He's a former chair of board, Canadian Mental Health Association, Windsor Essex County branch, and a former vice chair of the board of directors of the Canadian Mental Health Association, Ontario Division. He's a sessional instructor in estate planning and administration, third-year practicum, in the Faculty of Law at the University of Windsor, and he's a member of Law Society of Ontario's Solicitors Advisory Committee, charged with confirmation of competency standards for lawyer licensing examinations. His law practice concentrates in corporate, commercial, business, succession, estate planning, and administration, including wills, trusts, powers of attorney, and capacity. He's also a presenter at the annual Law Society of Ontario program, Practice Gems Probate Essentials from 2011 to 2019, and a chair from 2016 to 2019. Thank you so much for being with us today, John. Are you ready to go?
I am.
Awesome.
I believe the screen is there for everyone.
Yeah.
And I just have to indicate to everyone how much I've enjoyed the program. I was able to watch everything last week and watch most of today's. I've learned an awful lot. And, I do note that 80%, I think that in excess of 80% of the attendees have been caregivers for over 5 years. And with all that accumulated wisdom, they've been good enough to share some chat and so on and so forth. We've all benefited, and I've benefited, and I thank you for that. So in that respect, there's little I can add with respect to the hands-on. I may add today some specific knowledge pieces for some of you through the legislation, but I assure you I'm not going to go section by section. My presentation will be as much about my impressions developed over the years as to the black and white law, those sections, the specifics of the legislation, and particularly its utility or lack of utility to caregivers. And I'd like to think that it's all about the gray, not about the black and white. It's about the gray, both in terms of the legislation and also in terms of the very difficult issues that often arise, moral and ethical issues, gray issues, where more than one equally desirable or undesirable alternative presents itself for a decision. Because at the end of the day, it's all about achieving results in the best interest of your loved one. And my session is about how to go about it using that legislative regime and your accumulated wisdom and knowledge of the system to your best advantage. And a word about legislation. It sets rights, duties, and obligations, and also defines some liabilities. And in the context of mental health legislation, the HCCA, the SDA, and the HIPAA, rights really, and we're going to focus on rights of your loved ones, rather than initially rights of the caregiver or rights of the service provider or medical profession, more so obligations of caregivers and essentially liabilities of the service provider and medical practitioner, but in connection with the rights for the moment of the loved one. There was mention last week, properly so, of the conflicting rights of the loved one, the right to feel better and to recover and to take steps to recover, acknowledging that it's a lifetime task, versus the right to refuse treatment. And we are in a period of time in the current wisdom, according to the UN, and also to the courts, where it says the right to refuse treatment prevails. That being the case, a bit of my advice would be, well, then don't fight in court. If that's, don't go the formal route. Work to address the better rights, because we think the better right is recovery, of course, with ultimate goals. And I want to speak to that later on in the presentation, some strategies as how to do this. Of course, caregivers are given rights in the legislation, but you know, rights without resources is a hallucination in and of itself. Caregivers, and I say that because in the context of, or in another context, the presenter on a seminar in governance that I attended talked about, well, governance principles in an organization can be happy to do this or can be happy to do that and wants to do this and wants to do that. But the presenter at that point said resources or good intentions and vision without resources, in other words, money, is a hallucination. Well, adapting that to the situation we're in, we're talking about caregivers. And caregivers' resources essentially are time, conviction, and love. And caregivers have sacrificed considerably to make up that time. And we've heard, you know, the panel last week was excellent. And that was one of the themes, is how difficult it is as a caregiver, the time that it takes away from other things in life. Caregivers have sacrificed considerably. So that being the case, they've created that resource. How best to make that sacrifice and resource converted into resource work. So with all that said, let's get underway with a little more of the detail. Now, there'll be three sections. We're going to look a little bit at the substitute decision makers, rights and obligations. And again, I say that it's primarily the rights of the loved one, the caregiver's loved one, and the obligations of the caregiver. And again, about rights. Rights, as I say, speak to the black and white law. And I want to emphasize, as I said, the gray, how to make the legislation and the system work to the best advantage of the loved one, but also the caregiver and the service provider and medical professions. It's a collaborative effort. One goal, the goal is the best quality of life possible for all in the system. The loved one, but also the caregiver and also the service professionals. Pardon me. So you're looking for the best possible result in the circumstances that life has placed them in. And the caregivers, the loved ones, have pretty much been put in that situation involuntarily. Of course, the service providers and the medical professions, less so, voluntarily, not entirely voluntarily. But regardless, let's see what we can do to enhance the quality of people's lives given the task in front of them. Rights aren't as important for the caregiver. Of course, they're very important to the loved one. The service professional's concern, as I said before, were more liability. And if you look at the legislation, the HCCA, it talks about the service professional not being responsible if certain difficult decisions had to have been made due to emergencies or crises. And those are important in that legislation, even more so than the professional obligations, of course, are important. Secondly, we'll look at HIPAA according to the same themes, right? Obligations and liabilities. But I want to, and I may quickly slip through some of the specific provisions because I really want to talk about strategies. And in that regard, let's talk about legislation in general. All the HCCA, the Substitute Decisions Act, the HIPAA, they're all considered to be remedial. All legislation is really considered to be remedial. To correct conditions in life that are not correctable without some government intervention. And sometimes an acknowledgement that courts or the makers of the common law have perhaps not addressed conditions that present themselves in life adequately, or in many cases according to current modern mores of the day. So the problem is that necessarily the more remedial the legislation is, and the more controversial the conditions to be corrected, often raising moral or ethical dilemmas, the more detailed and prescriptive the legislation must be. My eyes glaze over when I read the HCCA and the HIPAA, and I'm a lawyer. There's a saying in the legal community that hard cases make bad law. Mental health decisions and legislation related to that are hard cases. You know, they're involving the person. It's different from commercial legislation when it talks about property. While that's important, here we're talking about individuals, their liberties, their benefit, and those sorts of things. The legislation isn't perfect. And the remedies outlined in legislation, the black and white of it, as I called it, are not often easily achieved by courts or formal process. And in some cases that they are, they don't result, so far as the loved one is concerned, to his or her best advantage. For that reason, I feel that the better focus and approach in decision-making for caregivers is to look to the non-specific, and in that sense, the gray objects of the legislation, the purposes, and state the broad, why are we here? Why is that legislation in place? The legislation is going to govern the decisions. Let's go to the general. Let's speak to the general objects of it to see if all parties to the decision are following it. The body of legislation, to use another analogy we often see in other contexts, is the forest. The HCCA, the SDA, and the HIPAA is the forest. The particular sections of each of those pieces of legislation are the trees. And what I'm saying is the best strategy is to focus on the forest, obviously, and not the trees. So, substitute decision makers, start with that, rights and obligations. Now, the power of attorney for care is only effective if the HCC applies to the decision and authorizes the attorney to make the decision. And in that case, you might have a situation where there's an application to the Consent and Capacity Board to depart from a loved one's wishes in circumstances where the substitute decision maker or the medical professional thinks that in the particular circumstances they're confronted with, the loved one would reasonably have altered his or her wishes if capable at the time the decision had to be made. So that's a situation where the HCCA is applicable. Or if the HCCA does not apply to the decision and the attorney has reasonable grounds to believe that the grantor is incapable of making the decision required. Now, we have to recall that a person who's 16 or over is presumed to be capable of giving or refusing consent in connection with his or her personal care. And what does that mean? Well, we've seen the definition, the two-pronged definition many times. It was raised often last week. He or she, the person is considered incapable if he or she cannot understand information relevant to the decision being made, or he or she is not able to appreciate the reasonably foreseeable consequences of a decision to go ahead, a decision to do something, or a decision not to have done something. And we'll get into a little more detail later on that. An individual may give written power of attorney for personal care if he or she has the ability to understand that the substitute decision maker has a genuine concern for his or her welfare, the individual's welfare, the loved one's welfare, and appreciate that the substitute decision maker, or that they may need a substitute decision maker to make decisions for them in particular circumstances. Now, when is a person incapable? Well, a person at the time of assessment And in certain situations, for example, there may be a difference if a person is under anesthetic and still affected by it. An individual may have capacity to make decisions as to some specific treatments or care issues, but not others. It may have the ability to make those decisions at certain times, but not at others. Now, there was reference made last week to the Ulysses Power and a bit of a discussion as to involuntary treatment. So I put a few of these slides in just so you have them. There's a lot of commentary about their limited facility. Under the HCCA, the power could be pulled, it's already pulled quickly, relatively quickly in any event, but it is a step that might be considered. The Ulysses Power authorizes the attorney and other persons to use necessary and reasonable force to determine whether the grantor is incapable of making an HCCA decision, to confirm whether the grantor is incapable of personal care, where such a finding is required under the specific power of attorney in place, or to obtain an assessment of the grantor's capacity by a certified assessor. And I'll go into some of the other powers it involves. Now, these are extraordinary rights, but these are the rights of a person to whom that are given to who I would call a social trustee. In a commercial context, a trustee holds legal title and rights up to property for the benefit of a beneficiary. The social trustee holds rights for the benefit of a social beneficiary, his or her loved one. And just as in the commercial context, where a trustee has duties and obligations with respect to the property he or she holds, so too does a social trustee have obligations to that social beneficiary, his or her loved one, to exercise his or her duties. And the more significant the duties, the higher the obligation, reasonably in accordance with law. Now, in this case, with respect to the Ulysses Power, it could authorize necessary and reasonable force to take the grantor to any place for care or treatment and to admit, detain, and restrain, may I say confine them, during the care or treatment. And it would also waive the grantor's right to apply to a consent and capacity board under the HCCA for a review of a finding of incapacity in connection with any particular decision. Now, these are authorities, as I say, that the loved one gives to his or her SDA, but it's given when the grantor has made the statement at the time of giving the power of attorney that he or she understood the effect of these special provisions, and also has and that he understood or she understood the ability to revoke them. Within 30 days after these powers of attorney are executed, an assessor makes a statement that an assessment of capacity was performed after it was executed. So the assessor does an assessment after and confirms that, yes, the loved one did make that statement and appreciated and knew the consequences of making that power of attorney and giving those powers. And also in the opinion of an assessor, the grantor was capable of personal care at the time of making it and capable of understanding the effect, I say. Now, moving on to HIPAA, I want to look at this again according to the three themes: the rights of the loved one, obligations of the caregiver, liabilities of the service provider medical profession, and also liability of the medical facility with custody of private information about the loved one. These slides are taken from the Office of Information and the Privacy Commissioner and from the Hotel du Grace Healthcare website. Now, let's first look at the purposes of the HIPAA, and fairly straightforward. The purposes of the Act establish rules for the collection, use, and disclosure of personal health information about individuals that will protect the confidentiality of that information and the privacy of individuals with respect to that information. And secondly, that will provide information to a right of access to that information about themselves, subject to limited exceptions established. A process for review and resolution of complaints in connection with the custodial's duties in maintaining privacy. But what exactly are we talking about? So what is personal health information? And it's prescribed in the legislation. It's orally recorded information identifying information about someone that relates to his or her physical or mental health, family history, the health care he or she receives, including who provided it, plan of service for an individual under the Long-Term Care Act, an individual's eligibility for health care payments, the individual's donation of body parts or substances or anything derived from testing or examining a donated party, an individual's health number, anything that identifies the individual substitute decision maker, anything that identifies an individual, and that is contained in the personal health record. And the primary purpose is to collect, use, and share personal health information is to deliver patient care. Primary purpose is patient care. But the information could also be used for administrative purposes, research, quality assurance, teaching, stats, fundraising, et cetera, those that comply with an organization's regulatory requirements. However, patient, client refuses to consent to a specific use, that refusal must be respected by the organization. Loved one or SDA, substitute decision maker, has the right to know why the information is being collected and why and how it's being used. The individual has the right to withdraw the consent at any time unless it's required by law. Circle of care. The circle of care isn't a term in the legislation, but it essentially is used to define those who are involved in the care or treatment of a particular patient. Access to health information is based on need to know to provide the current and direct patient care. The personal health information may be used for, as I say, research and education, such as education rounds for teaching purposes. As I've said, the patient generally has a right to access his or her information. And if it's used for purposes other than those that I mentioned above, it may be accessed only by persons designated by the individual. He or she will dictate, or the individual's legal authorized representative. Consent. Consent must be informed. Why is the information requested? What are the expected benefits? What are the implications of the release of the information? What are the likely consequences of not releasing the information? Express can be verbal, or consent can be verbal or written. And if verbal, it must be documented in the patient's chart. Now, this was reviewed last week. Quickly go over it again. If the individual is incapable of consent, here's the order of persons who would be given authority to act. First of all, an individual's guardian of the person or guardian of property, and that's an individual appointed by the Superior Court, or an individual attorney for personal care or property appointed under a power of attorney signed, executed, granted by the individual. Could be an individual appointed by the Consent and Capacity Board, typically under the HCCA, individual spouse or partner, child or parent, parent with only right of access, brother or sister, or any other relatives. Now, how do we protect that personal health information? First of all, who's holding it? The custodian is any person or organization who controls others' personal health information as part of their role as a practitioner, service provider, CCAC, the land, someone who operates prescribed facilities such as hospitals, obviously, psychiatric facilities, pharmacies, could be an HCCA evaluator or a Substitute Decisions Act assessor. Any disclosure of the information has to comply with legislative requirements and professional standards and procedures that organizations will outline in policies they're obliged to maintain under the legislation. Again, we're speaking to rights when we talk about challenging the custodian's compliance. A complaint can be made to the Information and Privacy Commissioner for bad faith. Commission conducts a review. An individual could also appeal to the courts, go to the courts. At Hotel Do, what occurs is that an individual is able to challenge the hospital's compliance to the Chief Executive Officer or Privacy Office. They have a procedure in place to review the complaints, investigate complaints, and if it's justified, Hotel Do will take appropriate measures, amending policies and procedures as they are required. In my mind, that is the preferable first step for a caregiver to take as part of the communication among essentially everyone involved in the system for the benefit of the loved one. I'm going to pass by this, the Hotel Do Grace privacy principles. They are in accordance with the provisions of the Substitute Decisions Act and HIPAA primarily. And I passed by that because I wanted to spend the rest of the time we have today on strategies. How do we make the legislation and the system work to the best advantage? And here, I want to say the best advantage of the loved one, but also the caregiver for his or her own account, not just as a social trustee for the benefit of his or her loved one, but for his own account. And I believe it's also important for the system to work to consider in this context the rights of the service providers and the medical provisions, the goal being the quality of life on the system, as I said earlier, in the circumstances that life has placed them in. But first of all, the duties of the substitute decision maker. I may have misspoken earlier. These are the specific duties of the caregiver as outlined in the Substitute Decisions Act. Some are shared. These duties are shared with service providers, medical professionals, and some involve obligations to be engaged, to be expected by an engaged loved one whose recovery at one point in time permits participation, recognizing, of course, if you look at number 8, one of the duties of the substitute decision maker is to consult with the individual, with the loved one, and also with the circle of care, but with the loved one to the extent that the loved one is able to participate. Bit of advice I would give, given the HCC requirements that talks with respect to, and just let me mention one, the general objects of the HCCA, spoke to the gray. The general purposes are to enhance the autonomy of persons for whom treatment is proposed, or to whom admission, for whom admission has been proposed, and also to allow persons to request that a representative of their own choice be appointed. Either they'll do so under powers of attorney for care, or be appointed by the Consent and Capacity Board. And also, and in this context, this is the key one, requiring that wishes with respect to treatment, admission to a care facility or personal assistance services expressed by persons while capable, as long as they were over 18, be adhered to. It is so important to get information from your loved one when he or she is engaged in his or her own care, in the stage of his or her recovery permits that to happen. The more you know about the person's wishes and values, and to have evidence, the better. Write it down. Better, have your loved one write it down. Have that document. One section I'll reference in the HCCA is section 59, which talks about principles for making decisions. And it specifically talks to knowledge about the wishes and values of the loved one. The more you have in advance, the better. In making decisions and strategy, you have to understand privacy policies and procedures outlined under the HIPAA and the organization itself. I urge you to learn as much as you can about the organization itself. Ask questions. You want to facilitate the best care for your loved one. Set expectations with the service providers, medical physicians. You want to stay informed about rights of access, consent, and obligations to personal information. And of course, you want to protect that health, privacy, and hold the custodian accountable, as we mentioned. Now, the enforcement of rights, because that's what we're talking about, of course. And rights are set out in legislation, but in my mind, they're hollow unless they can be enforced. And sometimes that's by civil action or courts. But it's really a little broader proposition than that. In the ideal sense, tangible rights are hollow unless the goals they protect or seek to achieve are met. And those aren't always, or even preferred, to be accomplished by formal action. Citing black and white rights in the legislation, section this and section that, but rather in pursuing the rights that have been set up, that the legislation has been set up to achieve, and what your loved one wants to achieve following his or her values. To achieve what? To achieve for a loved one's peace of mind, health. It's not the black and white, it's the gray. It's the nuance in the legislation and the general objects that the situation in which everyone is placed have placed people. My goal is to strive as a strategy to conquer the nuance, speak to the general. What are the general objects of the legislation? What are the general objects as far as care for your loved one? Being proactive about consent. Again, as I mentioned before, consult the individual on the values and wishes to reduce that ambiguity. So that happens under the HCCA. It could also happen under PHIPA and the SDA. Identify and prepare substitute decision makers. Written consent to accommodate disclosure. The caregiver. So again, this involves a loved one if he or she is in condition that permits engagement. Things to consider when making decisions, and all of these speak to the rights a loved one can expect to be pursued on his or her behalf. And by whom? Well, the caregiver, the service providers, and the medical professionals. The individual, in connection with the individuals, so does the service reflect the values, beliefs, and wishes while he or she was capable as expressed? Is independence, is the decision fostered with choice of service, are alternatives viewed? Is the service outweighing the risk of harm to the individual, or is the least intrusive? And finally, will it improve or prevent or mitigate deterioration of quality of life? And finally, in the few seconds I've got, I guess I've got a few minutes left. And I'm indicating this with props to the clinical ethicist department at Hotel Du Grace Healthcare. I want to take straight from the Hotel Du's website, a section called Ethics Framework. And it seems to me that it would be beneficial to everyone to follow an ethical framework that's set out in that system. Now, the ethical framework that Hotel Du Grace Healthcare has and other medical professionals live by is expressed in that section, primarily for them. But I think caregivers can benefit from that, and also for loved ones. Caregivers can benefit by acknowledging this medical profession imperative to see where they're coming from in their decision making, and adopting its elements as effective strategy to achieve what we want for our loved ones, while at the same time addressing the caregiver's own needs. Ethics. What's ethics? Well, first of all, it's everyone's responsibility, everyone in the system. But ethics is a situation, it's a branch of philosophy that critically considers what is right, what is wrong, what is good, what is bad, and most importantly, here we go again, all of the gray areas when struggling with best possible decisions. Ethics hinges on sound and valid justifications and reasons for decisions being made. What do we look at? YODA. It's about you and how you do it, but I'll talk about the sense of that in a second. We talk about observation, deliberation, and then acting. When I say you, it's not about the caregiver being right and the other person being wrong. That's the black and white. It's about the caregiver approaching decision-making in collaboration with others in a way that supports the loved one's better rights. The right to recovery, the right to feel better versus the right to refuse treatment to achieve the best goal. In so doing, you have to look at certain things. First of all, how do you know you're experiencing an ethical issue where there are no clear options? There may be two or more somewhat equal, desirable or even undesirable alternatives. Here's where we consider the rights versus rights. It involves important value-laden issues, involves more than just the caregiver and the loved one, and has implications. When you're looking at these things, it's recommended that you evaluate your own intuition, your own gut. What's best in your own mind? You appraise others' arguments because you want to ask perhaps the service provider or the medical professional if they'll answer, what's their gut? What's their intuition? Apart from what the legal framework requires, what's their gut? What it does, it clarifies and enables justifications for decisions that are made to benefit your loved one. It cultivates excellent discussion. So in connection with observing, what's causing the uneasiness or apprehension? How much time is there to come to a decision? Why is there a conflict or disagreement, if there is, amongst team members or between the patient and you as caregiver and perhaps the service provider or medical professional? You know, ask what the caregiver's gut reaction, biases, and her loyalties are. What are the intuitions, as I said, about it? Don't be afraid to ask the service provider what their intuitions are. It may take them back a bit, but it may help you at the end of the day to get on the same decision-making plane with. I've gone over time. The other elements you can check on the website. There's a YODA section under the on the Hotel do Grace Healthcare website. The other elements would obviously be to gather the facts that are involved. Then, when all the facts are in place, deliberate. Look at the alternative treatments. Look at the values of the loved one, the extent they've been expressed, and hopefully you've been in a position to compile what those are. You evaluate the alternatives, and then you act or direct the service provider or medical professional to act. Articulate the decision, the plan's implemented, and alternatives are evaluated. So, just to wrap up, legal information, the details of legislation. The black and white is not the same as legal advice. And a bit of what I've given you generally, because legal advice is the application of legal information to a particular set of circumstances. And what I'm telling you is that in our circumstances, in dealing with mental health and persons with mental health and addictions, what the focus should be is legal advice at the 10,000-foot level. Overview based on principles for the benefit of the loved one. And the advice is that you shouldn't be focusing on the black and white, that legal information. You can get that by looking it up, but rather on strategies to make it work for you, the benefit of yourself and also your loved one. And with that, I thank you. I have to give props to Spencer Hughes, student of law, who prepared all the slides and a lot of the detail in the presentation. And with that, I will ask if there are questions.